Yep.
Read the established rules of procedure for town board meetings adopted January 3rd, 1980.
Number 1, matters to be discussed must be on the agenda. Number 2, supervisor may permit additional matters to be discussed after all matters on the agenda have been acted upon. Number 3, the supervisor may set aside the agenda to permit those in the audience to address the board. Number 4, no member of the public shall engage in any demonstration, booing, hand clapping, or otherwise disrupt the formality of the town board meetings. Number 5, no member of the public shall be permitted to address the town board unless recognized by the supervisor. In no event may any such person speak on one occasion for more than 5 minutes. Number 6, any person speaking to the town board with the consent of the supervisor shall address his or her remarks to the town board. Supervisor shall give his name and the nature of his business briefly. Number 8, no person has the right to demand an answer to a specific question from a member of the board. All such questions shall be directed to the supervisor, who may answer them himself, bless you, or refer questions to the town attorney or to a town board member of his choice.
Or do these not qualify because he's not here?
When we get to that, we'll have an explanation for the meeting, okay? He's not here at this point. At this time, our town attorney, Abe Platt, would like to speak.
There are a lot of people here, I'm sure there's a lot of questions. This obviously is not really a place or a setup for a back and forth, so I would like to go line by line through what's being proposed to provide an explanation or rationale for the change, and just to give more background information on this project in general before we open the public hearing. So this is with regard to the first local law that is on the agenda, the E-code law. So, on E-code, what this was about 2 years ago, in mid-2023, the town of Cambria decided to retain general code services to do a codification of its various laws. Up until that point, the town's laws are passed sort of piecemeal, haphazardly. Local laws, ordinances, they aren't really organized. So Cambria decided to codify them, basically putting them in an organized encyclopedic form, which is what most municipalities had done probably 25 years ago. So it was long overdue.
Speak in the microphone so people in the back can hear.
Can anybody hear me? I've got to read, so I'll do the best I can. If it starts to get wavy, just raise your hand. I'll try to do the best I can. But I'm going to try to read too, so I'm trying to read from the actual document. So backing up, 2023, the prior administration, the prior town attorney, the town planner decided to undertake this project of codifying the town's various laws, ordinances, local laws, so that it's easier for everyone to research, to find a point of law, because without the codification, what you're left to try to go to the website or the books, and there are plenty. Each ordinance, each local law had its own animal. It was very cumbersome, and this is again to simplify the way you can access the laws that govern the town. So what E-code does is they have a legal team, they have a team that this is what they do.
No, you're good.
All right, this is what they do. They go through the town's history of laws, they organize them. As they're organizing them, they're organizing them alphabetically, which makes sense. So you start with animals, you go down to zoning. So again, even that is a simple little step to do. So as they're filtering through, they are taking the the sections in ordinances, the sections in local laws, and they're converting them to the town code. So they're reassigning chapter numbers, they're reassigning section numbers, they're organizing. As they're organizing the substantive parts of the law, the meat of the law, they are flagging for the town areas that are either inconsistent, outdated, or could need revision for a number of reasons. So they perform this codification, and at the end they generate this list of flagged items. They pose these flagged items to the town for consideration. The flagged items were then at that point, again in 2023, disseminated to the town attorney, to the town planner, the building department, to the highway department, whoever would have the expertise to weigh in on what we should do. And then a consensus was made, decision. We basically just at the end of last year, going into the beginning of this year, got through the process of formalizing all the decisions. So every issue that was flagged was either said, no, that's fine, we're gonna leave it the way it is, or if we have to make a choice because something is outdated, we choose at that point which way to go. The list of changes. So the list of changes is under Schedule A. So there are two aspects to the local law. One is to establish the town code. That's Article 1, the adoption of the code. That's basically just to adopt this format, post it online. It's in, Tamara had the book. It's in a book if you want to still read a book, but it's online. Go online, it's much easier. When you go to E-code, you'll see every town basically in New York State is on E-code. The second part is the Schedule A. Those are changes to the text of the ordinances, the text of the laws. Those have to be incorporated because we're passing a local law. Those are changes that would be incorporated in this local law. And I'm going to go through each and every line item of the Schedule A so that people understand why we're making that change or what is even changing, if anything. There are three main goals that the E-code team tried to impress upon the town, and three goals that were pursued by the town when considering these changes. One was to remove any mention of a set fee in these ordinances because the fees change over time. The town board has the authority to alter these fees. So they'll alter a fee. Let's say you have an ordinance passed in 1975. It lists a fee from 1975. The town board might have passed a resolution changing the fee several times since then. But if you go back to the law books, you got the old ordinance. So a lot of the changes were to remove the set fee so that going forward, any citation to a fee in the E-code, in the town code, will refer to the clerk's fee schedule. And if you go online, it should have a hyperlink, so you can literally just click on it and see what the 2025 or going forward, what the fee schedule is. So you'll always have an up-to-date idea. You won't have to say, well, this says it's $50 here. That was in 1980. I better call the clerk and see what it is, 2025. So it's to remove those set fees, make it easier for people to understand without having to make extra phone calls. The second goal of E-code was to remove internal citations. The zoning ordinance in particular was full of internal citations. That's citations to different parts of itself, so that if you wanted an answer, you would see this section, it would point you to this other section, you'd have to flip to that section, you'd have to read that, go back to the original section. The goal to remove the internal citations was to take out the reference to the other section and literally just print what you find on that page right there in the section. So it's designed to make it easier to read. The third was, because a lot of these areas of law had there's enforcement mechanisms and penalties, and they were haphazardly sort of ad hoc put into place over the years. There really is a wide variety of penalties. They're sort of all over the board. And in condensing and recodifying, modernization in New York State, basically, modern municipalities have siloed a lot of these violations into basically two categories. One, your misdemeanor or your violation level. The state law sort of dictates what the max for a violation level offense is in terms of fine, incarceration, etc. And misdemeanor, same thing, fine, incarceration level. Depending on when the original law was passed, you could be in the middle of both. So essentially what the code was trying to do was to standardize these penalties so that they made more sense. And you'll see examples of this as I go through. I can tell what issues were hot button issues in the year that the law was passed based on how high the penalties were. I think the time has tamped down some of the temperatures there. But those are the three things you're going to hear a lot of, are getting rid of the internal citations, removing the set fees, and standardizing penalties. So I will literally just I don't know if you have copies of Schedule A. Starting at the top of Schedule A, the first change. So now we are actually talking about changes to the law itself, not just the process by which it's codified. So Chapter 56, Animals. There are two changes here. The animals, this is a local law from 2010. So it was passed in 2010. The first change, 56.5B, changes the fee from $18 to $21. Why? Because since 2010, the state added a $3 fee that was enacted since 2010. We are revising it to incorporate that $3 fee. And since that time, a $10 late fee was added if you're late on renewing your dog license. So that's incorporated in to this code since it's passed since 2010. 3. So battery energy storage systems used to be housed under the zoning ordinance. Because the zoning ordinance was the closest thing that the town had to a compiled list of subjects, a lot went into the zoning ordinance. What this code is doing is sort of breaking that out into its own chapter. So what used to be sections in the zoning ordinance is now given its own chapter, Chapter 63, the battery energy storage systems. Section 63-12, there you see the amendment there. That is to change the internal reference because in the zoning ordinance, it refers to a section of the zoning ordinance. Now that this has a new home in the code in Chapter 63, it's changed to refer to in the code where you would find this, the penalty. So it literally is changing from a reference to the code to reference to, Chapter 288, zoning, Section 288, 1205. That's where it's going to be in the code. This is a lot easier to explain if you're looking at it. But again, this change just directs you to where this section is now going to be in the E-code. Chapter 70, this is a building construction and fire prevention. This is a section 70-11A, so that everyone's following along. This is a codification of a local law that was passed in 2023. So this law here has been on the books in the town of Cambria for 2 years. The reason why it was changed in 2023 was because just before the town implemented this, the New York State Building and Fire Code made these changes. So this is a codification of the local law in 2023. Building, construction, fire prevention, the code sections are now going to be broken down to Chapter 70 instead of just shoehorned into the zoning ordinance so that they're easier to identify. If you have a building code question, you can go to Chapter 70. The change that's being implemented here is in the local law. The 3 areas where an inspection of a public area is required. So you have the assembly area, you have the schools and colleges, and then you have all other non-residential occupancies. In the 2023 local law, it says at least once, and then it gives a range up to 12 months. In the law, it says up to 12 months. For Section 2, it says up to 12 months, and for Section 3, it says up to 36 months. The only change here is that the town is deciding we're going to set it to the max. We're just going to say 12 months, 36 months, because it had a range before. They're just picking 12, 12, or 36, so that it's clear. Because if you just look at the local law, it could be anywhere up to 12 months, 36. So it's just codifying and cementing what the actual requirement is for a law that's been on the books for 2 years. Chapter 102, flood damage prevention. This is a local law from 2028. At the time it was passed in 2028, there was a set fee.
2018.
2008. And when it was passed in 2008, it was a $500 permit fee. What they're doing is you're removing that permit fee, and you're just referring to the town clerk's fee schedule. You're gonna hear that a lot. We're removing a fee from 17 years ago and we're just referring to the clerk. That was a lot of money back in 2008. I can't imagine what it is now. Chapter 109, freshwater wetlands. This is an interesting one because when the town implemented its freshwater wetlands protection code, it included a note from the DEC in the actual text that was enacted, and the note was instructions on how to go about the decision of making exceptions, additions, or modifications to the provision of the act. That was a note. It's like essentially stage directions. So they put the stage directions in the body of the bill. This just eliminates that note because it literally is an instruction to the town board in how to go about thinking about making an exception when the case comes to it, and it refers to the department's guidance from August 6, 1976. So it's completely unnecessary. It was stage direction, so they're taking that out because it's just confusing. Because that's direct to the town, not the reader. Chapter 116, Games of Chance. This was a 1981 ordinance. It used to refer to the New York State Racing Wagering Board. That no longer exists. They've updated their name to the New York State Gaming Commission. This amends that by updating the name. Chapter 127, Mobile Homes and Mobile Home Parks. This was a 1975 ordinance. And I would imagine that in 1975, there was a lot of issues in the towns about mobile home parks because they set some pretty high penalties. But section 127-7B, we're again removing the set license fee and just providing it as a fee set by the board. 127-22A, that updates the citation because they referred to it as the fire prevention ordinance, when now that's been updated to the New York Uniform Fire Prevention and Building Code. So again, it's just updating what it's referring to. Section 127, this is reducing the penalties for a violation of this section. Back in 1975, if you violated this section, the law allows for up to a $250 fine or incarceration for 6 months or both. That's one of these areas where the penalty sort of falls in between the violation level and the misdemeanor level. New York State modern ordinances want to try to silo one into the other. This is in the middle, so basically the town is deciding to reduce that potential penalty down to the violation level, which penalties for violations in New York State are a maximum of $250 fine or 15 days in jail or both. So they're basically turning this down to the violation level. Again, it was passed in 1975. Maybe it was a bigger deal back then, but not so much anymore. Chapter 135, the noise ordinance. This was a 2010 local law. And basically what they're doing is they had to choose between where to set this. This is one of these, there's penalties that were sort of not really in one or the other. They're assigning this sort of as the violation level versus the misdemeanor level. So they're amending the penalties, the maximum penalty to be $250 fine or 15 days in jail versus the other decision was, do we make this a $1,000 fine or a year in jail? They decided to go on the violation side, so they're making that, making it clear in the noise ordinance. Chapter 142, notification of defects. That's a 1991 local law. They gave the town highway superintendent 5 days to notify the supervisor of any defects that were noticed. This we are revising to conform to New York State Town Law 65A3, which is, one thing Cambria does is it tries to match the state law. The state law is now 10 days, so they're amending it to conform to the state law, which is going from 5 days, 10 days to notice. Probably means not much to very many people, but they're revising that from 5 days to 10 days so that it, again, matches New York State town law. So, the property maintenance code. This is a 2013 local law. It was revised down to, the violation level because this is another one that didn't really fit into either category. So, it added the 15-day potential incarceration to the fine. So again, the choice is between $250.15 or $1,000 in a year. Property maintenance is not, it's not a misdemeanor level according to the town, so they're setting it at the violation level. Chapter 173, the recreational vehicles, the parks, camping grounds. This is a 1972 ordinance. The first change, the 173.5A, is to remove the set fee. Again, removing the set fee. And this was another one where the penalties were in between the two levels. So the town is amending to standardize this to the violation level. So then you violate the Rex parking camping grounds section of the law. It's going to be $250 max fine, 15 days in jail, and that's revising it from $50 fine and 30 days in jail, which is the law, was passed in 1992. Chapter 181, the sewers and sewage disposal. That's a 1985 ordinance. This is the first section is to revise. It's to make an internal citation manageable. This area is given a new section. It's referring to a new section in the code, so that literally is just to make it not refer to the old ordinance, because we're going from ordinance to code. 181.5S is again to update the New York State Plumbing Code, which in 1985, perhaps they referred to it that way, but we're updating it again here to the New York State Uniform Fire Prevention Building Code. Section 181, that's again, we are picking here that we are going to land in the misdemeanor level here for violations of the sewer backflow law, because you could do a lot. This is a 2018 ordinance. The first change is again to remove those set fees. The second change is to change 30 days to 1 year. Attorney, because the penalties are, it's a misdemeanor, so it's a crime. Everything else is violation level. So it really is important to try to make these consistent. And again, as you can see, we're sort of going back in time and sort of rearranging these things that are a bit all over the map. Chapter 271, wind energy systems. Again, like the battery energy storage systems before, this is again just reciting to where the penalty section is going to land in the code. Chapter 278, that is an amendment again to remove set fees. And I think this is why everybody's here. We're getting to the zoning section. I'm going to go slow, so if you can't hear me here, raise your hand. I'm going to be deliberate here and the best I can to explain what's happening and why. Personally, as an attorney, I like E-code because it makes my job easier. It makes it easier to find things. It makes it easier to cross-reference things. The zoning ordinance in Cambria is difficult. It is large. It unnecessarily refers you around. So it puts you on a chase to find an answer that does not need to be. So I'm going to I'll go through these codes. A lot of them are designed to make this easier. And I'm going to try to explain why. So the first one might as well be we might as well just get right here, because this is why I'm assuming 95% of us are here. There is a proposed definition change. 288-200, the definition of a farm in the definition section of the zoning ordinance is being revised from 5 acres to 7 acres. Why? Because the definition itself refers to a section of Ag and Markets Law that says not less than 7. So this was flagged as an E-code for an internal inconsistency. So we have the front part of the definition says 5, and the back part, if you go to the law it's citing, says not less than 7. So the E-code says just revise it so that it's consistent, which is what is proposed here. But I think there's a lot of confusion as to the import of this particular definition, and I'm going to try to explain this in a way. I'm going to try to explain this in a way that makes sense, because it's going to be hard to explain because it doesn't really make sense. I agree.
Order. You're not gonna
I-
disrupt this meeting.
I agree.
You're not gonna disrupt the meeting.
I don't think that there should be a definition of a farm in here because it's irrelevant. And I'll explain why. Yes, but the definition of farm in this ordinance is meaningless. So, the definition of farm is in the definition section. The definition of farm, the word farm as a term, does not appear in any of the actual land use sections of the ordinance. So if you go to the ag district and you look at the permitted uses, it doesn't say farm. It says agricultural activity. It says animal husbandry. It says horticulture. It says agritourism, because those are what is defined in the ordinance. And just to give you, there is a reason why farm is here. I don't think it's a good reason because it just confuses people. But I will just say this. Newfane does not have a definition of farm. There are farms in Newfane. The definition of farm,
Come to order,
the
please.
definition of farm varies from town to town to town to town, but only one municipality that I know of actually uses farm as a land use provision. That's the town of Wilson. That's why they did that, that's up to them. But the town of Lockport, the town of Royalton, Newfane, Somerset, they don't use farm because farm is a blanket term, which is why it's here in this definition. Because this definition here refers to the agricultural assessment. The ag and market section that this refers to has to deal with how you qualify for an ag assessment, the ability to be taxed as a farm. It says 7 acres and $10,000 in sales, or if you have less than 7 acres, $50,000 in sales. But it's about an agricultural tax exemption. It's not about land use. We don't use, and again, I say we, everybody but Wilson, we don't use farm as a land use in terms of different, because it's too broad. So we split it down into agricultural activity, which has its own specific definition, animal husbandry, own specific definition, horticulture, own specific definition, and agritourism. So if you were to just strike the farm definition out of the ordinance, nothing would change. If you were to leave it at 5 acres, nothing would change. If you were to set it at 1,000,000 acres, nothing would change because the ag exemption that it's referring to is set by state law. There's nothing that the town could ever do.
Hey, we're gonna start sending people out the door.
I can tell you right
We're
now
gonna start sending you out.
that the town of Cambria has no intent of having this change be substantive in any way. It was an internal citation. If you have 5 acres and you grow crops, you are permitted to do so because you're engaging in agricultural activity. If you have 1 acre and you are growing crops, you are engaging in agricultural activity. The only one that has any kind of a size aspect to it is animal husbandry, because if you've got less than 5 acres, then you need a special permit because the town needs to make sure you're able to keep the animals safely, humanely, and away from the neighbors, and that's the only one. So agricultural activity doesn't matter how big you are. Horticulture, it doesn't matter. Again, animal husbandry is the only one, and you can get a special permit for it if you're reasonable. If you want to raise chickens on one acre, you just have to be okay with it. But the thrust of this is just to correct this internal inconsistency, because it says 5 and then it points to a law that says 7.
Why not keep classy?
This isn't a question, this isn't a back and forth, people.
I've given my opinion on it. I'm just telling you why the change was flagged and what the rationale is.
It's not a question and answer right now.
The-
And it stays the same, why are we changing it?
It's not a question.
Why not just leave?
I don't want to talk over you, but your question has landed. I can hear it, so I don't want to be rude, but there's a lot still left. So, 288, 200, we're changing automobile laundry to car wash because it just makes sense. I don't know. It's almost funny that automobile laundry's in there. Section 305, about keeping transient roomers and boarders, they're getting rid of that because that was an attempted reference at seasonal farm help, and that's, again, governed by ag and markets. Whether you have the right to do that or not, you're gonna be governed by ag and markets, so it's sort of superfluous. Everyone knows that's what the town intended to by transient roomers and boarders. Playhouses, tool houses, and garden houses are deleted because it's unnecessary. These are not structures that require a building permit, so you don't need permission. You don't need to be told that you can put a playground up. So the problem is when you list things that you don't need a building permit for, or that aren't structures that the town is going to need to consider accessory structures. If you make a list, the implication is that you're excluding everything else. So rather than having a list of 3, they're just deleting it because they don't need to be set out. We don't want to give anyone the impression that the only other structures you can have are the playhouse, the tool house, the garden house. Same. We haven't even opened the public hearing yet. I'm just going to try to get through this. So 400 and 406, that's again the residential analog of the ag district changes we just went through. Section 288, 401J, the agritourism section. This is one of these cases where we are literally just putting the text of that provision into the section instead of referring you to another section. So instead of pointing you to where to go, we're just going to print this paragraph for you so you can just read it right there. Same thing with section 288, 500. In the medium density residential use district, it lists the permitted structures. And then it gets to a point where it says, and everything else that's considered permitted under these 2 sections. Well, rather than make someone flip back to the previous 2 sections, they're literally just putting it here in writing. It's not adding a new permitted use, it's just saving you the time from going back to the 400 section and the 300 section. Same thing with section 288, 600. They are literally just saying, these are your specific permitted uses, rather than making you go back to the previous 2. So again, they're not expanding or contracting any permitted uses. They are simply saving you the flipping through the 3 pages, and it's an obvious change to someone who reads the ordinance and has to. They're adding a new section to 288, 101D, which when someone goes to sell their house, the building department is going to now have to notify the future owner in writing within 30 days that this property has a special use permit attached to it. It's permanent off-street auto storage parking. They had, if you go into the ordinance, you'll find it, they had a list of like every conceivable hypothetical setup you could have, businesses broken out, and each one had its own parameters. So if you had a warehouse, you had to have this many parking spaces, and it had to be this orientation. And it was 3 pages long, and if you happen to want to open up that kind of building, and your lot maybe isn't going to be conducive to that particular arrangement, you're going to be in a problem. So what we're doing here is eliminating those specific parameters and just giving more discretion to the planning board to look at your property and help figure out a parking space orientation that makes sense, rather than trying to shoehorn people into what at some point someone thought was appropriate for each little breakout, either business or public place, because there's a lot of them there. Same thing in 1109. They're removing those specific parameters and just giving the planning board more freedom to take a look at your actual parcel and try to make a plan for parking and offloading and standing areas that make sense, rather than constraining them. So the town basically has general parking rules and general offloading rules, and they're just referring to those instead of the specific enumerated present requirements, which could be hamstringing to somebody in reality. Section 288, 1113B, again, just removing a specific fee. 1126.4 is deleting that penalties and remedies section because the bed and breakfast penalties had their own penalties for some reason. They were sort of their own, because again, it was passed in its own piece of legislation, so they're just eliminating that and making it consistent with the rest of the zoning penalties and setting it as its own consistent catch-all. So what they're trying to do here is instead of having 6 or 7 different types of penalties, just having one condensed penalty section and referring people there. And we'll get there in a minute. That's another one of these ones that bears an explanation. So this is the big one here. 288.1129M4. The present zoning ordinance has an enforcement section that sets forth a civil penalty structure, which authorizes the building inspector to issue civil penalties for violations that they are alleging are occurring. And they are permitted to withhold moving forward on a building permit or a zoning application until those civil penalties are paid. I have a huge problem with that because you have judge, jury, and executioner in the same person. So that needs to change. It needs to change. This enforcement mechanism is in addition to the New York State town law enforcement mechanism. So the New York State town law has its own list of penalties for zoning violations. Uh-oh, I'm losing battery. I'm gonna do the best I can. My battery's dead. So.
Yeah, okay, Terry.
I'll get it.
So, New York State town law has its own basic default violation penalties, enforcement mechanisms. The town is able to add on to it, which it did here with a civil penalty structure. What this is proposing is to get rid of the civil penalty structure and literally just copy and paste the New York State Town Law 268 penalties and enforcement mechanisms to just make that clear that that's the only penalties that the town has for zoning. It's already on the books, it's in the New York State law, but right now we have the civil penalty structure that needs to go. And everyone knows it needs to go. The building department knows it needs to go, which is why they've never issued a civil penalty, because they recognize that's problematic. I have never recommended one in my prosecutions for zoning because it's problematic. It needs to go. I don't know when it came into being, but it has no purpose anymore. So this section is eliminating that civil penalties framework and literally cutting and pasting the New York State town law penalties in there, which again are already on the books. If you were cited,
What are those?
it breaks down the fines into offenses. So you have first offense, second offense, third offense, and it sets a max penalty for each and a max incarceration for each. And bear with me for 1 second. Let me get my longer explainer out. So, anytime there was a zoning, I'll try to cut to the chase. Anytime there was a zoning enforcement mechanism in the zoning ordinance, it's being changed to what the state law is. Because just to give you an idea, the special permit section had its own penalties and enforcements. Those were, fines, $500 to $1,000 for first offense, $500,000, etc. They're making every penalty just setting it at the state town law level. And hopefully I have the whole thing in here. So, It's gonna stay.
Or what it is?
It's going to stay. The civil penalty part in the law is the same figure that the state uses. The state uses, it's a fine that's issued by a judge. So you're looking at $350 for the first fine, and then it's this period of years, you get a second fine, third fine. It goes up to $1,000 maximum for persistent violators. So what you're doing in addition is you're adding on the incarceration provisions that are already in the state law as well. So what this amendments to this section are trying to do is make people aware of what the law is so they understand. If you don't know that there's a state law that dictates what the max penalties are, because it's not explicitly in the ordinance, you might not, I guess if you're going to decide how badly you want to violate the zoning ordinance, if you don't know what the penalties are, it's not really fair. And additionally, there's a civil penalty framework that is dubious at best and needs to go. So what we're basically doing is just making what is already the law in black and white writing so everyone can see in a section and stripping out that civil penalty framework. And that's again across the board because there are different penalties in different areas. Your special permit violations were one set of penalties, they're just making it all the same. It's all the state law. They're trying to make it consistent throughout the ordinance.
So that means it's the same for all the different towns then, because they all have to be regulated to the state law?
A town is free to supersede the state law if it wants.
Speaker time.
If they want to make it, if they want to have it, a few do.
by socialist communists.
Quiet.
They could make it worse. They could make it better. Keep it the same.
Quiet.
The town of Cambria
People out.
is simply codifying what's already on its books. It's not changing anything other than a specific reference to what's available.
Getting a lot more progress.
All right, I think I've done the best I can to explain what's happening with this. We're taking what's already available. If you were facing a zoning enforcement proceeding, you would still be able to be sentenced if you were found guilty by the judge to the state penalty. We're just letting you know here in the ordinance, this is what they actually are, and we're getting rid of the civil penalty framework.
Just open it up to the public at this point.
Hang on just a minute, we're gonna get to that point.
So, trying to just move forward, 1207 again, we're just removing the specific fees because they might not match what's currently on the books.
But it's only gonna make it right with Martin.
In relation to the municipal code of the town of Cambria, an abstract of which is as follows.
Okay, we're gonna start out with Linda Smith. Linda Smith.
Hi, some of you may know me. I,
Can we use the microphone?
Yeah, but they're allowed to hear a public meeting law, agree.
And I'm saying that out loud because honestly, for anyone who was brave enough to put their name on that list up there to speak today, I think everyone had a little sick feeling in their stomach, worried about either retaliation or being flagged as a troublemaker. For any of you who did not sign it, that is a sign that there is something wrong, that you guys are not listening. I've been to many meetings. This is by far the most organized you have been. And it's only because we have been demanding answers. You actually presented yourselves today professionally. I'm not quite sure why the supervisor isn't here, but I'm getting very, very discouraged with how you seem to just kind of disregard everyone continuously. My biggest concern originally was constables when that got passed. And for anyone, you can go online and actually see these meetings and how they've addressed the public, how they disregard our concerns, how they won't listen to reason and reasonable ideas. And now here we are, okay, with this
Ma'am, do
big
you
law
have some-
change,
Do you have
yes.
some comments?
Yes, I know, the comment is happening now.
Let's
The
get this going.
comment is happening now.
5 minutes.
And now, you guys, surprise, surprise, after the town has approved constables, who has a lot more jurisdiction, okay, in our town, that nobody on the board could even answer me. And when I asked if any of you read it, you told me, well, that's the town attorney's job. And it's on tape. You guys can see it. And now you're gonna pass laws, okay, whether you're disguising them as something that's, oh, it's state mandated, it's fine. But you also have armed yourselves. And you're acting surprised that so many people don't trust you? Like when I come. When I come. For actually writing the amendments. Was that our town attorney? Or was it a team of professionals? Who wrote them? Who wrote them? Who wrote them? How can you vote on something that you can't even recognize who wrote it? And if it was any of you, and especially for our town attorney, for you to sit there and know what the hot buttons are. You know what the hot buttons are, but yet you're still, oh, I don't agree with it, but you're still going with it anyway. I'm disgusted. I'm embarrassed. I'm embarrassed. I'm getting talked to from friends that live in other countries that are like, what the hell is going on over there? You have let us all down. You've let down generations that have been here forever and built this town. You've let down people who have moved here to do better for their families. You have failed. All of you.
Okay,
I live at 4611 Town Line Road. I have reached out to this board prior to this meeting, and I've asked the board to delay the vote, form the comprehensive plan committee promised to the town in their own plan, and let that group, along with a sample of residents, review these laws before adoption. It does not seem that that's going to happen tonight. I also want to address the assumption that I, along with a couple other people here, are just bitter folks who tried to create change or outrage in the community just to further our political agenda, as someone put it. You did this. I just simply shared facts and allowed people to come to their own decision. Yes, some of these items in this new proposed law have been in place. And there is just a mere wording change, but now the people are seeing these laws and they're paying attention. The outrage is not about changing words. It's about the fact that a board allowed these laws to be adopted, whether it was 10 years ago or now. People are paying attention now, and they won't stop after today's meeting. This town has weaponized definitions against me in the past. Personally, I'd like to address the proposed change in our local law number 2 that would raise the definition of a farm from 5 to 7 acres. I spoke with many residents who are deeply concerned about the change, and I want to highlight both the legal and practical reasons why it should not move forward. There's no state requirement for a minimum acreage. Farms any size can qualify under New York State law. In fact, 4 other towns in Niagara County do not provide an acreage requirement in their definition. And another town has a definition of only 3 acres. New York State is not telling you to change the town of Cambria's definition. According to New York State Department of Ag and Markets, a farm operation under Ag and Markets Law 30111 includes that land, farm buildings, equipment, and practices that contribute to the production, preparation, and marketing of agricultural products. Importantly, such operations may consist of 1 or more parcels of owned or rented land, contiguous or non-contiguous. The state's official guidelines for review of local law affecting farm operations also provides a definition of a farm operation that is not based solely on acreage. The state's own guideline in that document warns that imposing strict minimum acreage requirements may be considered unreasonably restrictive on farming, especially with a certified agricultural district like much of Cambria is. Raising the minimum from 5 acres to 7 is not required by state law, and it risks conflicting with these state provisions. This change would not only harm small, viable farms, it would also rewrite the meaning of farm in every other section of our town code. Any place where farm is mentioned, from zoning allowances to agritourism uses, would not be limited by the new 7-acre threshold. Would now be limited, I apologize. I don't think it's coincidence that this would especially be damaging to agritourism businesses like the Forsyth Tavern, which depend on the legal farm definition to host events, sell farm products, and attract visitors in a way that supports both agriculture and our local community and economy. Officials have attempted to reassure residents by saying that change won't affect current farms or lots under 7 acres, but there is no grandfather clause. Verbal assurances are hollow, and if the law doesn't reflect them, many here have learned that the hard way, that they will come after you. The definition of a farm impacts more than livestock allowances. It affects building permits, repairs, and property rights. Without legal protection, farms could lose their statuses and structures may become non-conforming, potentially leading to denial of permits. And if, as officials say, we are not changing the acreage requirement for keeping farm animals like chickens or changing rights for current farms under 7 acres, then why change the definition at all? The citizens of the town that you represent do not want you to change the definition, and you do not have to. Consider this. A bad law that's never going to be used is still a loaded gun on the table. Visible, dangerous, and unnecessary. If it's truly never going to be used, it should not be there. Since we've ruled out that 7 acres is
Mrs. Patterson,
not a state requirement, I must ask the board, why do you believe that Cambria's law should change from 5 to 7 acres?
Your 5 minutes are up.
Time is on.
Robert Winslow
Nope.
is on the clock.
That's okay.
Robert, you're on the clock.
I think Robert Winslow will have the same thing to say, so I'll let him say it for 5 minutes now too, instead of just 1 for me. Robert,
Could you please give us the money?
No? Robert Winslow, 4988 Bridge Road, Lockport, in the town of Cambria. I was lucky enough to get a variance to get horses, but I only had 3 acres. Then I was lucky enough, a farmer was selling property, and I bought enough. Now I got 6.8 acres, and now you want to change my farming to 7 acres, which is not right. Just like the constable law, where he's just gonna be for the courts. Now you want him to do other things, and we had insurances that all he was gonna be was for the judges. It didn't work out that way. If you change the farm acreage, you're putting a lot of people in jeopardy just because the laws are okay, you can have horses or whatever at 5 acres. That's subject to change now, because it's not considered a farm if it's under 7 acres. I got tens of thousands of dollars so my wife can have horses. We're getting another horse. What if you change the law next month that now you have to have 7 acres and I've only got 6.8? It doesn't make sense to change something that works. I bought out here so it wasn't a homeowners association, and I don't want a homeowners association. It's a beautiful town, and I love it. I just want to keep it as a town. I don't want it to be Amherst. I don't want it to be Pendleton. I want it to be Cleveland.
That's not asking a lot.
And your jobs are tough. I couldn't do it because I can't put up with stupid. So I give you guys a lot of respect for taking this crap. But you can't change something that works. That's gonna affect a lot of people down the line. And I'm really nervous about it because what went as a constable is changing, so I really don't have a lot of faith that things aren't gonna change in the future. That's all I got to say. I just wish you think of everybody. Thank you.
Okay, we got. Name's Richard Alicio, I live at 4869 Bridge Road. Everybody is voting against it, they don't want anything to change in our community. We don't want to be Pendleton, we don't want to be Amherst. And by the way, is anybody affiliated with real estate or something of that nature? May make a profit out of this?
Subdivision. We don't want them.
It could be from somebody from out of town or whatever. I get things in the mail, I sell your farm. What for? I like where I live. I've been there for 45 years. I don't expect to change. You people want some teeth? I'll give you some. I used to be head of the president of Niagara County taxpayers. It was a law. It's called Home Rule 24. We don't have a county executive. That means you have the right to vote on their salaries.
Woo, yes.
Here's how you do it. You get a petition, and you have to find, at the Board of Elections, who voted in the last gubernatorial election for it in the town of Cambria. Last I heard, we had about 5,500 people. Take a third of that off for children if they don't vote. So what you do is you go around and collect them. I used to do that. I'm too old to do it. You gotta do it. But you can not only vote on their salaries, you vote also on the appointed people. That means the building inspector, that means the town attorney, that means town clerks, assessors, whatever. You know, another thing, they say, well, it's the stakes of housing. I sold some acreage just to lower my taxes by $2,000. Lo and behold, a year and a half later, I can, everybody got a new assessment? Just, the assessment went up just as much as I lost when I was paying off. So, in other words, $79,000, back up again. Oh, and that, don't forget now, you got the school tax, and they want their piece of the action. And by the way, do you know that also that the school tax, it should go back to the last time that you put it on, they passed it on the ballot? Okay, permissive referendum, as if you voted, as if you voted that time themselves. Well, guess what? Just casted your vote. But there's enough people here that finally saying about Home Rule 24. I did it in the county, did a memorandum, the county attorney. He was both the Democratic Party leader and the attorney, conflict of interest. So if you want to hold your feet accountable, use Home Rule 24. All you have to do is get people to sign, but you gotta explain it to them. I took on the county. The town should be damn easy. That's all I got to say for now. I'll be back.
Okay, we have the Deanna, 4006.
Meeting to which in the past 6 years that I have lived here, I have been to probably 90% of them. For those of you who know me, you know that I have been very active in the fight against the industrial solar project. That's been proposed. And again, I have a true appreciation for the farmers. I sorry, I am a city girl who moved here because my husband and I followed our daughter and her husband and our grandchildren here, and we just love it. With that appreciation, I need to say our group has, the bottom line is we too want to preserve farmland, okay? And that's really the reason why we formed the group against the solar. I truly wish we could have seen you all in the past 6 years, okay? We had meetings, we had fundraisers. Again, being a part of the community and this wonderful town of Cambria involves a lot of things. So I thank you for your time.
Hi, I'm Roseanne Boffman. I live at 4500 Lower Mountain Road. I came because we have 7 acres. Doesn't affect us. But New York State agricultural law, a farm is not defined by a minimum acreage like 7 acres. A farm is generally defined as any tract of land used in commercial production of crops, livestock, or livestock products, and may include associated farm buildings. The size requirement is flexible. A farm can be less than 1 acre. And this is right from New York State markets and law. Right from And I guess the next part I have a problem with is your zoning laws, okay? You're here and you're saying no other municipality around here has any type of imprisonment for a violation of a zoning law, okay? Not Pendleton, not Barker, not Newfane. Yes, for a noise ordinance, for property maintenance, something like that. But a zoning ordinance, there's no community. You can pull up all of them. I read them all today. Not one of them are you going to jail for a zoning ordinance. Imprisonment for zoning is uncommon in rural and agri county. Noise, property maintenance, and nuisance codes are much more likely to have a short-term jail penalty. So why are we adding it on ours?
Yeah.
That's all I got to say. I don't have 5 minutes worth, but that's all I got to say. When you get your
It's
money.
Peggy Schuler Chisholm. I was born and raised on that farm, 3933 Lower Mountain Road. My father, born there and died there for 92 years, as his father before him, and as my 2 brothers, Don and Tom Schuler, now run it. These people have built this farm. My grandparents owned the Hillside Inn, Tony and Bernie Adler, that fed all these farmers that feed all the city people. No offense, honey. You need to do your jobs. You need to respect the people that live here. They're not city folk. They're farmers. They feed your children. They feed your grandchildren. And they feed you. Stop trying to change what's worked here since, what is it, 18 something? Yeah, 1808. It's worked. Leave it alone. These people know what they're doing. They pay their taxes. They own land, and it doesn't matter if it's 1/3 of an acre or 150 something like my family is lucky enough to have. Leave them alone.
And I think the main thing is, I'm surprised all of you people that are on the board that voted for this, looking at all these people that are so concerned about it, why don't you guys say to yourselves, this was not a good idea. I think that we should go back to what we had originally. And the lawyer already had said that we do not have to meet those New York State requirements that you guys are so important wanting to meet. So why are we trying to do that? It doesn't make sense with what the people are saying.
Oh, a little humor doesn't hurt, does it? MIC, NNLL,
Thielen, 2633 Youngstown Lockport Road. Okay, so we're gonna move on. Tyler Booth.
All right, so Tyler Booth, I think everyone here knows me. I'm the owner of the Forest Tavern by need, not by choice. I also live on Lower Mountain Road. So I've sat through all this, and I know you all hate me or listen to me, but my takeaway is, it sounds like you had someone who does not live in our town interpret our laws and then tell you what they meant again. So obviously, I think you're all in agreement that there's issues with this as it's standing. I think that's pretty clear across the board. So what I think everyone is recommending is that we take a step back, maybe get a board together with community members, maybe get everyone in one room and hash out our laws and make them something that works for our town. I'm just asking for a lot. I know you've already put 2 or 3 years into this process, but the problem is you did that privately. You did not include anyone from the community in this process. And a lot of this, it might be okay if the community trusted you. That's the world of difference here. Last meeting, the community came together and called upon the town board for accountability. We made it very clear that we do not trust this town. And that is the biggest issue on why we're not trusting you with these powers. Yes, you might promise you'll never use them, but let me tell you, I can tell you that people will. If it's not you, someone else after you. And in that, I'm going to tell a brief story that I think you've all forgotten, and that I don't talk about often. But in 2021, I was accused by James McCann of building a bathroom on the second floor of my building because I had asked for a permit to build an ADA accessible bathroom in my basement. He denied me flat out and refused to give me the denial letter that I could appeal, just to be a dick. He took me to court and tried to put me in jail for a bathroom that he said I built without even bothering to ask me, ask my attorneys, or do an inspection of the building when I was inviting him to come and do that. I came to the town board stupidly, naively, and said, hey guys, I'm having an issue with one of your employees. I need your help. And you all ran me through the mud about it, made me your victim. And the part that is the kicker.
Do it.
You can do it. Do it.
Don't let the bathrooms.
My mother went to hospice. We got the call, it was time. It was my court date, my second appearance before Judge Sedita, or not Sedita, Judge Jowdy. And my attorney called the town's attorney at the time and said, hey, he needs to not be there for this. Is that okay? And Billingsley said, no, if I didn't show up to this hearing, despite what was happening in my life, he would ask for a bench warrant against me. So say you won't put people in jail, you've never done it, you sure as shit tried.
I'm gonna start clearing the room. If you don't maintain your authority, please.
So I never got an apology for any of that. But to be honest, that is time that I will never get back. She died. I was in your courtroom because of James McCann lying, and you all knew it. I came to you beforehand after you all knew it, and you allowed it to happen. So trust is gone. There's no trust here. You need to work hard to get this town to trust any of you or your processes. And yes, you have a new attorney. Awesome. I was not protected then, and I don't think I'm getting any assurances that I or anyone in this community is protected now. You have built a system with a building department designed to target people. You don't like them, you target them. So every single law has been weaponized against us. So until you can write these laws to ensure that everyone's interpretations are the same, you don't have any laws here.
That we were reassured 7 times that we were going to hold a meeting with your building department, and that never came to fruition. And this board tonight, we were reassured 7 times that we were going to meet with them and discuss issues regarding the building department.
Did it happen?
No.
We're not talking about it.
Nothing, right?
Why?
Well, seven?
I can take the mic back. My time is done. The secret is they said that they could not coordinate the 2 of them in a meeting with their schedule, and it would be a conflict for them to meet with us.
For 7th time? Oh, come on. Representation.
All right, I live at 5266, been a few years since we've seen each other, Luis, neighbors. Okay, sorry, live at 5266 Bear Road, moved in a couple years ago, 6-ish. I live down the road from Luis. I've talked to her husband before, tried to buy land so we could do fun things at our house for our kids. We were told that was not possible by her husband. Sorry, getting nervous talking in front of people.
That's right, girl. Keep that.
I grew up in Barker. We had horses, chickens, anything you wanted. I brought my kids out here so we could live a good life. I get constantly harassed by my neighbor. He calls the town, and what happens? I get served by you guys. Threatened to be taken to jail. Have to go to court and prove myself that I'm not running a business out of my house when your local tree company that everybody knows drops logs in my driveway. Nobody called me. Nobody showed up at my house. I had a stranger walk into my backyard and serve me paperwork to go to court.
What?
Because Park Hill dropped logs in my driveway for my wood-burning stove to heat my house. And then when I explained that to the town, they said, we have to check and see if you got a permit to have a wood-burning stove in your house that was not in the city. We were told we had to go to the town and prove that we didn't run a tree service business out of our house. I don't know how that we were able to prove that besides just telling you guys we weren't doing it. I've also had issues with, obviously, my neighbor. He calls you guys, tells you guys that my yard is splitting out his yard. You come tell me you're gonna tear up my driveway to replace pipes that are already replaced. I explain they aren't. The guys are really nice. I'm not mad at them. They're just doing their job. But when you guys are taking word of mouth and acting on it, why don't you check? Why don't you back yourself up? This all tonight was a bunch of noise, hot air, and nothing. You're wasting everybody's time. I run a business, not in the town of Cambria, thank you. I work for a corporation. I sent all of my employees home early today so I can leave and be here. I followed cars here that were doing well over the speed limit to get here to make sure we were here. I told them all to get out of the building, lock the doors, and left. And I drove from Lockwood to here. I work all over Western New York. My job at my company, I permit and I do sales. I know all of those things. And when you guys come at me and tell me that I'm residential, and I can easily pull up your map and say, no, I'm not, the line is between me and my neighbor, and I am residential agricultural, and you want to argue with me and I shove it in your face, there's a problem. How come I know your laws better than you guys? Frustrating, annoying. It's a waste of my time. I have 3 children at home. I don't look like it. I hear that all the time. I have a 14-year-old. She's going to high school. And I have to tell her, don't worry about the neighbor that wants to stand on the property line and stare at you and watch you outside with the dogs, because then he calls you guys and tells you, my dogs are running at large. And what do I get? Letters in the mail that I'm going to be fined. I mean, do you guys back up anything? Do you check? Because when my kid tells me another kid did something, I go and check. Instead of punishing my children. I mean, you guys are the parents of the town, correct? That's what you should be doing. Taking care of the kids. And they're all really mad. I just don't seem to understand why you need to change something that doesn't need to be changed. Because there are plenty of people that don't get permits from you guys.
Time's up. Duncan Ross. My wife and I own Arrowhead Spring Vineyards on Town Line Road. I commend the attorney for using a full hour to go through that. This I'm not got paid for the hour at one point in my life. Awesome stuff. Never. Right closer. Thank you. Yes. Thank you. First comment is you spent a lot of time and a lot of money going through this with the zoning, and you didn't ask if any of these laws really made any sense, if this made sense. The new regs really read like a draft with a lot of errors, with some omissions. I would also urge the town to form a committee to look at this, go through that old stuff that doesn't make any sense anymore, make it make sense, make it streamlined, line it up with the state if you want. But make it make sense, make it make sense for Cambria. The danger of going with this law as it is, incomplete, is that it's not well thought out. There's still a lot of gaps, and there's gonna have to be variances, permits issued, because you guys haven't thought through all the details. Farm wineries are mentioned. You don't mention commercial wineries. You got commercial wineries in the town. We're farm winery, but there's commercial wineries. They're totally different standard. You got wineries in the town that do use 51% of their fruit to make their wine. You got some that don't. That's not necessarily the standard. And why would you copy and paste state ag and markets regulations into your zoning and the rest of it? The town doesn't have a very complete understanding of code. We experienced that firsthand when we built. We built our house in 2004, no problems. Cliff and Don were the building inspectors. Got it done and coded. When we built our big building, we had to hire engineers who helped us navigate the code with the town, which sadly aggravated the code officer and led us to 18 months of delays, documented. Piled on with lots and lots of frivolous letters, demands, et cetera, including DOT, DEC. It was a mess. I'm a different person now than I was 10 years ago because changes aren't good. We got through it with patience and help from the engineers, but we had the resources to do that. A lot of people don't. The town doesn't enforce its current zoning. Increasing the complexity of the rules is probably not the answer to fixing code problems. Common sense says we need simplification and fairness. The town should have to prove that they fairly enforce the current laws before we give you guys more stuff to do and more laws to enforce. The town is inconsistently heavy-handed with some residents, while others have to meet different standards. This building doesn't have sprinklers. Looking at the taverns issues, it appears that other businesses in town are able to operate without meeting those standards, including some wineries. And, you know, the video I saw, you know, Louise, you've got a nice saloon there in the sunflower thing. You know, why aren't the standards for everybody? I don't think it's right. You had a sawmill business that was shut down a few years back. You still got a few people running a sawmill there. Why shut down one and leave others? Like, what's going on? None of these were permitted, some are allowed. Do we want to empower the building department with new punishments that include jail time without having a fair and equal process or fair and equal laws that are administered equally and fairly? I think a lot of people have expressed that there's a lack of trust. And the lack of trust is because you go to build something and I just get abused. And finally, what are the problems we're solving here? I mean, I've been here 21 years. The town's had anxiety over anything that a new business wants to build or do. And they think of all these scenarios that may or may not happen and often don't. And then we jump through hoops. And we constantly jump through hoop after hoop after hoop. And those hoops keep moving. Is this just another anxiety attack? Why not take a step back, get a committee, get a review? Thanks.
Not surprisingly. My comment's more along the lines of, well, also that these things need to be applied equally, of course, but also the town seems to lack the ability to reach out and ask questions when it should be necessary. And the cease and desist letters are something that I'm thinking of, having received more than one myself. One of my favorites came in October of 2016 when I received a cease and desist letter from Mr. McCann, the building department, saying that I needed to turn off my cannons, my noise cannons at night. They were going off all night long, and cease and desist. Make sure you make it happen. And I assume that that means I was deputized that night. Maybe we don't even need a constable because I was told to go turn off these cannons. They weren't mine. So rather than reach out and ask me, and then I had a sheriff show up at about 11 o'clock, I was kind of glad. I mean, it wasn't my cannon, it was still going off. And that sheriff did the sensible thing. He waited with me. We took a walk, me and my jammies, him in his nice uniform, to the corner of my farm in the dark, and then he could hear that the cannon was not on my property or near it, and the issue resolved with him. Didn't stop the cease and desist from the town. I had asked years ago for a constable's uniform since I was deputized. It hasn't shown up yet, but the cannon's been turned off. But this kind of thing seems to be a regular occurrence where the town does not ask first. It just decides what you're thinking. We have letters from the town telling us, oh, your intentions with this building are XYZ, therefore you must PDQ. No one ever asked us our intentions when we were building our production winery. The town was calling it a banquet hall. I mean, this kind of stuff needs to stop. And what we were forced to do and how our winery had to have different things than anybody else's here, it's just not equal. This town should be equal. If we're going to have even more zoning rules that are used to pick and choose to enforce against some of us and not others of us, I don't understand what the point is. Law is supposed to be equal. Justice is supposed to be blind, right? And no one ever wanted to be in a place where one person was judge, jury, and executioner. That's all I have to say.
Use it. Hold it down a little bit, Joe.
I'm always loud, but I promise I'm not here today to attack anyone personally. Just to address the deep constitutional concerns surrounding proposed local law number 2, and obviously a lot of other things. I live in Lockport, but my family still owns land here in Cambria. And my heart is with our farmers, our local businesses, and this entire community. This law doesn't just affect us here, it sets a troubling precedent of government overreach that could ripple across Niagara County and beyond. Let's start with the foundation, the 2021 Town Comprehensive Plan. a document that was adopted as our legal guide for growth and preservation. The plan pledges to preserve our rural and agricultural character, to protect farmland as a vital economic and cultural resource, and to support agriculture, agribusiness, and agritourism without placing undue burdens on our farmers. It calls for recognizing agriculture as the backbone of our local economy, safeguarding farmland for jobs and future generations, and encouraging young people to take up farming. To make this real, the plan mandates two specific committees. One, an agricultural committee to review proposals like this one. And two, a comprehensive plan implementation committee to ensure every decision aligns with these goals and to update the town comprehensive plan yearly. Neither committee has been formed. This isn't just an oversight, it's a direct violation of the procedures the town put in place over 4 years ago. Moving forward without them leaves our community vulnerable and undermines our constitutional republic. But it's not just about local rules. New York State Agriculture and Markets Law 305A offers strong protections for farm operations within Certified Agricultural District 7, where much of Cambria lies. It prohibits unreasonable restrictions unless there's a clear public health or safety concern. And the Commissioner of Agriculture can step in to overturn any local law that crosses that line. Proposed law number 2 raises the minimum farm size from 5 to 7 acres, imposes special permits on all small operations, and enforces a whole new slew of zoning enforcements. This sets the town up for a lawsuit it is likely to lose, costing taxpayers dearly. And let's be honest, there's no state mandate for a 7-acre minimum. The town has made this choice on its own. The people have heard the supervisor and town attorney call it just an administrative update in public hearings or updating to ag and market laws on the news, and that's misleading. We've seen this lack of transparency before with Forsyth Tavern. The town botched a liquor license vote back in July, refused a certificate of occupancy without cause, and lost in state Supreme Court in 2023 for illegally revoking permits, all of which hit our wallets. This law risks impeding that costly pattern and also eroding whatever trust the town has left. The town of Cambria's Code of Ethics, established in 1930 under Chapter 10, is designed to keep our leaders accountable. It prohibits conflicts of interest, misuse of position to secure privileges, and any conduct that raises suspicion of breaching public trust. Yet we know board members own farms, farm stands, and agribusinesses, businesses that directly compete with the small operations now facing new restrictions under this law. That's a conflict staring us in the face, and a violation of the 14th Amendment Equal Protection Clause. And when the law's impact is downplayed as administrative in public hearings, it only deepens the distrust when the actual changes are revealed. The code requires a board of ethics to investigate these issues. If that board is incomplete or it's self-conflicted, especially since the board appoints its own ethics committee, and we also know there's family ties among some officials and employees, it means the town could be breaking its own ethics rule right now. But the town doesn't show you who is on the ethics board online. We need truth and transparency to restore trust, but that will never happen until we see accountability. And this law is exactly the opposite. It gives the town building inspector the ability to revoke permits without due process. That's a violation of the 14th Amendment. Threatening citizens with jail time over a new barn stand ordinance for not having your grass mowed, and apparently these other causes. I consider that cruel or unusual punishment for victimless crimes, a violation of the 8th Amendment. Citizens avoiding public meetings because they're worried about retaliation, that's a violation of the First Amendment. So it's called for accountability. This vote will confirm whether the town stands for transparency and constitutional rights. Don't pass this law, form these two committees, and if you can't fix this conflict of interest, resign. Because this is not something I want.
Tonight, this is awesome. I came here from the city of North Tonawanda to have a better life. And I don't like living here right now. I'm going to be honest with you. I don't. I'm ashamed of what's happening. But in any event,
Under the guise that this local law is only instituting some administrative actions, AKA putting them in E-codes, in reality it is much more than that. Changes to the code have the potential to affect every resident and taxpayer in this town. You had to have known that this was going to be a big deal. Perhaps it would have been beneficial for each of you to have scheduled office hours at Town Hall on different days at different times so that residents could go to Town Hall and actually find someone there that we could talk to. I believe that there are too many additions and changes to this code which have not been thought through. There are also errors. I think that it would be in everyone's best interest to have a committee formed consisting of citizens across a wide range of demographics and occupations and members of the town board. That committee should be able to make the necessary corrections to this code. A delay to vote, I believe, is warranted in this case. One such area for further scrutiny is the area of penalties for violations. This new law gives the building department policing power. Is this really what you want to spend what you want them to spend their time on? Is this really what you think the taxpayer-funded salary should pay for? This is not what they should be doing. Looking for slip-ups by residents and business owners in order to punish them should not be their main responsibilities. They should be working to educate the public on building codes, not persecuting them for their mistakes. This department used to be run by men who showed compassion for the residents. They did their jobs with common sense. Duncan referenced Cliff Birch and Don, who were in the building department when I built my house. They were wonderful men. But this building department is no longer like that. What is the process for assessment of penalties? Is this process defined anywhere in the town code? What recourse do residents have against the accusations made against them by the building department? A likely result is more lawsuits against the town that you'll spend more taxpayer money on. I'm already concerned about the amount of taxpayer money that has been spent either as a plaintiff or as a defendant from somebody suing you. Spending on legal services will most likely go up above the ridiculous amounts that I'm sure have already been paid. So jail time was removed from the zoning ordinance in 2022. What made the board at that time determine that it shouldn't be included? Documented in the minutes of the February 10th, 2022 town board meeting, during the public hearing for that amending the zoning ordinance pertaining to penalties, an explanation was provided by Mr. Roberson, town attorney at that time. He stated that words such as conviction, imprisonment, and incarceration should be removed because they trigger certain rights of the defendant due to the Bail Reform Act. What has changed since then? What's the rationale for adding this back in now? We've heard of many examples of overreach from within the building department, and those examples weren't arbitrary. We've heard a lot about them tonight. Businesses seem to be the biggest target, yet now you're going after possibly all residents. Singling out certain members of our community for whatever reason is not only illegal, it's immoral. And it is discriminatory at its core. There is discrimination going on in this town. We all know that that's what's happened in the past. And when is it going to stop? You were elected by this town, but the building department was not. Enough is enough. Please do the right thing and stand up for your constituents. Think about us for once. Businesses aren't going to come here and thrive. People aren't going to want to come here. And you're going to find fewer people being happy to live here.
715 Plank Road, and I agree with everything that's been said. I think the adding of criminal penalties just further adds a weapon to zoning ordinances that I think have been proven not to be very helpful to the residents. The one thing I really would like to know is, usually when something like this goes through, there's a subcommittee that kind of helps put this all together. usually a member of the board, maybe the supervisor and the attorney. And then there's usually discussion brought back to the general board on some of the decisions that were made. That is not available for the public to see what actually went on. I'm assuming it went on. You guys had to make decisions at the penalty level. So, going forward, I would love to have that stuff put into the work meetings and discussed. I went to the work meeting today. Obviously, a lot went on this past month, and there was no discussion. I was hoping to see like some of the board members say, yeah, I think maybe we've gone too far. Maybe I didn't realize, the 5 to 7 acres kind of controversy, but there was no discussion. So I don't know where each and every one of you actually feel on these topics, and you may vote yes, you may vote no, but I'm not going to know why, which is very important to me. So I would just encourage you guys to, on your vote tonight, if you vote, at least say why you're for or against it. I think that would be helpful come election time and having people know what they're voting for.
Thank you.
So now that we all know how the board stands, it really doesn't matter what anyone says, in my opinion, because they're gonna do whatever they want no matter what. Unless the board changes, they're gonna do whatever they want. We all know that, it's been going on for years. So my opinion would be an eye for an eye. Let's find out what businesses these people own, whether it's Sunflowers, and shut them down. Let's protest their business and shut them down. Spread the word. Sunflowers, what's that?
Except they tried that a couple years ago. Now she's on the board and she wants to be a bully.
Yeah, but if we don't show up to the Sunflowers.
Now listen, we're not gonna attack.
I got the microphone, you don't.
Listen, so it's our time to shut down their businesses and let's do the homework. We're not gonna attack people by name. We're not gonna attack people who's out.
You really like control of everything, don't you?
Yeah, but I referenced them, I didn't say no. All right. No. So in general, we all know what to do. An eye for an eye, it's our turn. So we know that nothing's gonna change unless the board changes. So now, let's do our part and give it, yeah, exactly.
Have a show of hands, who in this audience supports this law that's going through? Just to give them an idea of what we're thinking.
Nobody does.
Raise your hand if you support these new zoning changes.
But standing up on the board and knowing that you are not allowed to enter any of these businesses in Cambria has to be a rude awakening, knowing where you stand in this community and the people that you're supposed to be representing. And I just think it's time, an eye for an eye. Shut them down.
Okay, is there anybody that wants to speak that hasn't spoken?
The American Revolution started in response to the Stamp Act that imposed a tax for many printed items in the colonies that required using stamped paper supplied out of London. In addition, the Townshend Act attempted to tax and enforce compliance through additional regulations. The American people did not like this overbearing and overreaching rule imposed upon them without representation that was in line with their newly acquired freedoms. Eventually, the people went to war with those attempting to impose these new rules. For 8 years, they fought back against this oppression. And finally, in 1783, the people won. 30 years later, the Forsyth's Tavern would be built in Orange Corners, 3 years before the town of Cambria even existed. In the following 220 years, it endured many conflicts, wars, and attacks, but is still standing strong. Alas, the previous 220 years would not be the last conflict. She would stand to fight. The attacks started again in 2017 when the tavern's new owners attempted to bring the tavern back to life and teach those of us living near and far the history that is so abundantly rich in this area. For unknown reasons, personal and private, out of spite, the town board council have fought hard to prevent this gem from shining bright for all to see. With the family names of those sitting on the board today and in recent history, it's sad to see that in a mere 3 to 4 generations, they have lost sight of what this country and the town of Cambria once stood for. Your great and great grandparents once fought hard to enjoy freedoms from oppression and overbearing laws that this town board is now actively imposing on all of Cambria, just like the British Empire once tried. They cannot win. We will not let them win. We, the people, decide how we want to live our lives and how we're governed, not those who abuse an elected position they now hold. If any member of the board sitting in front of us today can honestly stand up and deny that they have no knowledge of the history between the town and the tavern, shame on you for not knowing what's going on in our town and acting in the best interests of your constituents. If you are aware and choose to say or do nothing, you should just step down from your position as you are involved in collusion. It's 2025. Good old boys club and its mentality have no place here, especially in Cambria.
I'm at 4874 Upper Mountain Road. I moved here 21 years ago. When I picked Cambria, I looked at different areas and what was allowed for farming, not farming, horses. I had a horse. I had a horse in Ransomville, and I wanted more horses. So we moved from the city of Tonawanda and bought our house in Cambria. The previous owner to me bought land from my neighbor to be allowed to have horses on the property because you needed 5 acres. I have 5.5 acres. I don't want to have to get a variance to have my horses because I bought here because I could have them. I was a mounted deputy with the sheriff's office for 16 years, volunteered. Very proud of that.
Thank you.
Right where I live on Upper Mountain, we have a lot of horses. Horses across the street. Some people call it Horse Road. We're very proud of what we do there. My neighbors have a big horse farm. They own a lot of land. There's things in this that will affect them. I just have my own personal horses. I love having them. I take very good care. I'm a widow of almost 4 years on Monday, and it's hard for me to keep up my property, but I do a very good job of it by myself, and I do a lot of the work myself. I don't want to have to ask for a variance. I don't want to have to fear that I can't say I have a horse property anymore because I don't have 7 acres. When I sell my house, I want it to be able to be sold as a horse farm because it increases the value of my property. And that's what I built it to be, a valuable horse farm. And I would just like you to take into consideration, just a little person like me, I don't sell anything, I don't farm. I just raise horses. I love them. They are my life. And you're gonna take that away from me? For what? Just to change a number? Like, you can say it's not gonna affect me as an animal owner, but down the road, it's gonna affect me. We all know it. I don't want to have to apply for a variance. You could say no to my variance. I might have a neighbor that moved from Williamsville, which I have now, and they're farming, but they might decide that they don't like my horse farm next to their house that's built farther back. But I was there first. Out of all the properties, my house was there first. And I want it to stay classified as a small horse farm with 5.5 acres.
So my name's James Durrell. I'm at 2958 Barry Road. I moved here 30 years ago, and I moved here 30 years ago because it was a different town. And people were nicer. The town board was, I wouldn't say easy to deal with, but they weren't doing the kind of things that were taking away people's liberties. And I stand for liberty. When I find out that a bureaucrat has power to put me in jail for a violation of a code on a piece of property, that's kind of scary. And you guys shouldn't be promoting that. That's not good. Okay. If these same people can come onto my property without me inviting them for any reason that they choose, that's a violation of the Fourth Amendment. This is not good. So I would ask the board, please, think about what you're voting on. Think about what the people here have said today, and take the constituents' comments into your heart, and do not pass this vote that you're putting forth.
Hi, my name's Jeanette Miller. I live at 5716 McKee Road. I live in Newfane. But when I started my journey in Newfane, I ended up in Fort and I had to fight for 5 years to farm on my own property on 70 acres of land in an agricultural district. And so I joined the Farm Bureau, and I sat on every seat in the Farm Bureau. I see some Farm Bureau people here today. I don't know if they're going to speak on behalf for you farmers. I would hope so. I sat in the vice president and the president seat at Farm Bureau, and so during that I worked a lot with ag markets. I also sat on the state committees of Farm Bureau, and then I created my own organization to help protect farmers for a different right, but in farming. So anyway, I understand what the lawyer said, and he is correct in stating there is a part of ag and market laws that does talk about assessments, and that does require 7 acres of land. But that's not what their law is reflecting. It's too vague. You guys need to clarify that, because there's multiple parts of that ag and market law. And when you state 7 acres, I'm reading it right here, 7 acres, and then in accordance as described in 301 of New York Ag and Market Law, there's different parts of that. Clearly your constituents need to know there's a difference, because your right to farm is protected by being in an agricultural district. And then you're protected by ag and market law, and you can farm on any part, any little bit of land or not, and that's what's going to protect you. 7 acres has to do with if you want a tax assessment, and so you can get tax exemptions on parts of your buildings and stuff like this, and that comes with a requirement of making a certain amount of money on your farm. But you don't have to make money to be a farm. You live in a right to farm community. It is your right to farm on any part of your land that you want to, whether you're a homeowner like my friend over here, who I had to go to Cambria court for years because he started a small farm on his house property. And as a Farm Bureau advocate, I lobby and I also do advocacy work, and I showed up to court and I apologize for our person over here on behalf of them, because I had to miss things that had to do with my family and not as extreme as yours, but they should have apologized immediately for their predecessor. So I'm apologizing for them for you, because me and other people in this room had to go through it too. And they're gonna put you through it. That's what's gonna happen if you guys leave it vague. I'm gonna end up in front of you guys, in front of your board. You guys have seen me before, I know Matt, right? And I've had to talk about different parts of farming, and there's other parts of farming that are coming in that you guys are gonna be very upset with, which is cannabis farming. It's a protected agricultural crop now. I see that you're passing something about Connex boxes. Connex boxes are used for that, to keep it safe inside. It's also used in other parts of agricultural farming, so don't let them try to do beyond trying to get rid of Connex boxes and other things that small farms can use that to do microgreens and other things on their small pieces of property to keep them out from being eyesores for the neighbors. But you guys aren't protected. Also, they can't come onto your property. So I know this because my town building inspector is not allowed on my property. He said he was, he's not. Neither are the police. They have to have a warrant. You can stop them at your driveway. You can say, you are not welcome on my property. If that building inspector or constable enters your property, call the other police. If it's a sheriff, you don't want them there, and they try to come in and pull a gun on you in your own driveway like happened to me, well, you call the police and you tell them to remove that police officer from your driveway, and now they have to call you from the end of your driveway to come in. You have rights. What you don't know is what exactly they are, and it's to make sure you're protecting your land and your property. They don't have a right to come in there. They can make an appointment. If you let them in, you let them in. It's like letting in a cop without a warrant, right? Just know your rights. You guys have to make this more clear. You tried to make it clear, I heard you, as a lawyer, say this only has to do with tax law. But that's not what we're hearing, because there's a room full of people here, and they don't trust you. And I don't trust you guys, because I had to go through it, and I didn't even live in this town, right? And I've been, so, mail that here. Also, oh, sorry, one more thing. New York State requires an SAP, under SAPA, SAPA, that there is comment periods for laws to be made. Usually 30 days or 60 days. They bring them on a register. They have the people make comments on them. They go back and they vote about them. They bring them committees, like they said. So I love that small towns think they're above and beyond the law, but if New York State has certain procedures and they want to do the procedures that New York State does, then they should probably follow the SAPA and make sure that we're posting what we're going to do. But then we put out a comment period. Then we revise the comments from our constituents. And then we might have another comment period after we make revisions. And then we pass laws.
Yeah.
And I own Augustus Sun Winery on 4515 Bear Road. And I had a big speech, but everyone's already covered everything that I had in my speech was basically transparency, equally treating everyone the same, and forming a committee to revise what we've all got to listen to for a very long time that needs revision, obviously. If we're using the sign-in sheet, which I think was for comments, but if we're using that for today, I'll just say about 100 people walked in after me, never got to take the sheet. I actually had the sheet taken away from me while I was saying the Pledge of Allegiance. So if you'll notice, my name's there, but not my address. Anyway, I'm just going to talk about a personal experience that I had with the town, which just highlights one issue, which was I actually owned a 7-acre lot across from my property. I should be able to do just about any of the things that we talked about on it. I actually received a cease and desist based on an April Fool's Day post that was made by my business and was told that I was not allowed to farm on that property with animals. I was not allowed to do any animal husbandry or anything of that nature. That was a safe 7-acre lot. So I just wanted to give that simple example of how the people are being treated differently in different areas, and that it is an ag residential zone.
Evening, everybody. I don't think there's anybody in this room who knows who I am. Is there anybody here that knows me? Not one single person. I moved out here about a year and a half ago from California. Northern California, we have a 500-acre ranch. We have 140 acres up in Oregon, a cattle ranch up there. I gotta tell you, I moved out here to run an aerospace company. And when I moved out here, I rented the house out there on the Freedom Run. And lived there for 3 months looking for somewhere to buy. I bought 8.4 acres out here in Cambria because I liked it. I like the area, I like the people. And I've been to a couple town hall meetings. One of them was a constable meeting. And I gotta tell you, folks gotta listen to the people. Gotta listen to the people here. It's a charming area. People love it. Got a bunch of people here not liking what's going on. You gotta listen to the people here, all right? They changed California, and I don't wanna see this place change. It's a nice area to keep it that way.
Anyone else? Shirley Earl, 44, 23 North Ridge Road in Cambria, and we've lived there, I've lived there all my life. Our family bought the place back in, I think, 1913, something like that. And it's a farm, it's been a working farm all that time. I think the thing I take away from this meeting tonight more than anything else is that there's a lack of understanding and education between the town and the board, and things that are going on. I sat on the local school board for 17 years, and I was county legislature for 7 years. Rich, I remember it's something we got into. Speaking but I think more than anything else. Oh, I'm sorry.
Yeah.
That better?
Yeah.
Okay. I think more than anything else, I take away from this that anyone who is on the board or is elected better be prepared to hit the streets, because you need to get out there and talk to people. You need to have town meetings that are not just the meetings that you have every month. I know sometimes you walk into the town meetings and it don't get that warm fuzzy feeling that you'd like to have. And I think you need to spend more time with the constituents. Okay, thank you. That's all I have to say.
I live at 4643 Saunders Settlement Road. I have a garden. I'm not a farmer. I'm a girl that's from the city. I've been at my home for 25 years. And as you can see, I'm against solar. I know that has nothing to do with what you're talking about right now, but I want to bring this to your attention because it's important. I went to get my mail the other day. And this was all across the front of the property, across the street from you. And it says, redesignated local. The property right across the street from me has always gotten hay. I know that at one point, the Wassicks planted Timothy grass, so the hay is good hay. And I'm not sure, but I think that Mr. Oval owns the property. If this has anything to do with the solar panels coming in, I want everybody to be aware of it. The reason, if you can see the grass, I have this, is the town came and cut grass down along the ditch. So it was no longer on the grass. I didn't take it from where they put it. This was all laid down and had been cut. But I want you to be aware that somebody redesignated that farm that has the hay to be lowlands. It's never been wet. And I don't know if it's significant or not for the solar, but I want everybody to be aware of it. And that's all I have to say.
I was afraid to talk because I am afraid of retribution, because I love where I live. But I see all these people behind me and not a single person is on board with what you're doing. And I see names on the name tags of the board members, and I know that these are farming names. We're a right to farm community, and what you're proposing, it goes against everything that Cambria stands for. I moved here because I love the farming community. I came from Williamson. I came from all the built-up areas, and now it feels like we're losing our rights to do those things. So all I really have to say is keep Cambria, Cambria.
For way too long. I was 9 years old when this started. I'm a freshman in college. And my mom, when I was leaving home, she told me, don't get arrested. That is the amount of fear that my mom has for me coming here. And my sister, who's from Italy, didn't want to come because she's scared of getting arrested and deported. Just want to reiterate that.
We're gonna get to that later in the meeting. Oh, thank you.
3 Shunpike Road. If anybody was at the last meeting, I spoke at the very end because I get so darn nervous about this. But my family has been at Warren's Corners in Lockport for over 125 years. We had a big farm there, and we never had these kind of problems. But at any rate, the other thing I wanted to say was this past week, I found out that my family was related to the Warrens. I am a first cousin, 2 times removed from Elmer Warren. Not that it makes any difference, but hey, I'm here. And I'm very, very disappointed in the town board for not getting together with the Forsyth people like you promised, or like the supervisor promised. Maybe you guys didn't. I can't remember every one of you that was at that last meeting. But if you're gonna promise you're gonna do something, you should do it. And if not, why don't we know it? And why don't we know why the supervisor isn't here now? I said it last time, this is ridiculous. You guys have got to start talking with each other and with the community. You're listening to everything, but you're not giving any answers. Why did these things come up? Why now is it 7 acres instead of 5 that they need? I don't know all the small stuff. I really don't. I'm sorry about this. But start talking and start doing it now. This is what your town wants you to do. Please do it. Thank you.
If you're moving that thing, when it's obviously not there on a temporary basis, the building department's concerned with it's being used as a structure. It doesn't have safety factors like a way to open it. It's because it's being used across the town as a structure, which it doesn't require an inspection or
Is this structure going to be exempt from agricultural uses?
if it's protected agricultural activity, we have to.
It is absolutely a protected agricultural activity. Everybody, Connex boxes are a protected agricultural activity. They do not have to be moved, although they are movable. You can grow microgreens in them. You can do other types of cultivation in them. They are used to have a controlled climate, to keep out pests, to keep out deer or predators. They're also used in cannabis cultivation. They're used to help keep in. We can't deal with it. I will not. Nice to meet you. Superintendent. Maybe put that in there as an exemption under farms. Just take out the definition of farm.
I read all of the stuff on this. You essentially told the county that you're passing this law because the building inspector lost in court. I read that transcript as well, and he lost because he could not give the court a building code that he could cite. It was undisclosed or uncited building codes that was the issue here. So I'm kind of confused on if we're passing this law because it's a safety issue or if it's an aesthetic issue. Because as I checked, we don't live in HOA. If it's a safety issue, wouldn't it just be easier to train your building department on building codes and let this work out like anyone else who's ever had a Connex box or a storage container? They're pretty common. Building departments deal with this stuff. We're just flat out banning it because your building department doesn't know how to regulate it, and that makes zero sense to any of us. That's all.
And involved in this from the beginning, this is sad news. Sad news. All I can say, as a board member and living in the town and being a member of the group, that we're going to keep fighting however we can. But at this point in time, I think we need to come to a conclusion that this project might go through. The best hope we have at this point is the hope that they run out of money to build the project. There's rumors out of Washington that some of the funding's been cut. We got to hope for that at this point. We're going to meet with the attorney next month to see if there's anything that we can do. That's what I got on it. Negative declaration on secret. Can we make a motion? We're just going to open it up for a motion. Motion on local law number 2.
There's consideration. If the board is considering taking no action, then should take no action on seeker this evening.
What is secret? What is
The
it?
environmental review, the state environmental review, to assess any environmental impact of the proposed local law.
I'll make a motion to table local law number 2.
I'll second that.
Mr. Hercom, seconds. All in favor? I can make a motion. Okay, so we'll start with this. I'm making a motion to table local law number 2. And second by Mr. Hercom. All in favor?
Aye.
All against? The ayes have it. Local law number 2 is tabled. Local law number 3, I'm gonna make a motion to table that also.
I'll second that.
Second by Mrs. Brockman, all in favor? All against? The ayes have it, both local laws are tabled. Procurement. Steve?
Civil Service Guidelines, be it further resolved that pursuant to New York CRR 315.3, subsection C2I and II, is determined that the town attorney shall be an employee of the town of Cambria for all purposes, including purposes of reporting to the New York State Retirement System. In making this determination, the board has considered the following factors supporting the conclusion that the attorney is an employee rather than an independent contractor, as set forth in 2 NYCRR 315.3 C2I. The employer shall control